What's up, everybody? Day 10 in the Karen Read trial, and we get some answers we've been waiting for, especially to some questions you all had that made a lot of sense that hadn't been asked yet. And we also have quite a few unpopular opinions, I think, that are going to come out in today's video. So make sure you stick around. Let me know what you think. Let me know if you agree or disagree, because today was wild. A lot of cross-examination and a lot more Alberts taking the stand as Karen Read continues to point the finger at them for the cover-up. So we start the day with cross-examination of Brian Albert. We talked a lot about his testimony, even how he started, how it seemed like he had a lot of experience. Also, at the end of the video, remind me to tell you why I'm late tonight, because it's really cool and I can't wait to brag on her later. But the defense, I think, noticed it too. And I think the beginning of the defense's cross-examination, regardless of if they'd ever admit it, and a lot of people might not want to admit it, I think they also think Brian Albert came across as a good witness during his direct examination. Not a surprise. A lot of witnesses do. Not a ton in this case necessarily, but a lot of witnesses do come off as really strong witnesses in cross, especially if they have a lot of experience testifying. Well, the defense wants the jury to know just how experienced Brian Albert is, especially when digging into some of his experience and what he did or didn't do or knows or didn't know happened in this case. And it jumps off right at the beginning with how experienced he is, and gets a slip up that I don't think the defense even saw was coming. That was just a horrible start for Brian Albert. I think he was on his back foot, to use a fighting analogy, from the jump in this cross-examination.
Okay, whenever you're ready, Mr. Jackson.
Thank you, Mr. Albert, this process is not the first time you've testified in a court of law, is it?
No.
In fact, you were a police officer for either just under or just over 30 years. Is that right?
Yes.
During that time, how many times would you say that you testified in a court of law in any capacity?
I would say 100, perhaps.
So you consider yourself to be an experienced witness?
In what aspect? In as far as being a witness as a police officer?
You've experienced testifying in a courtroom?
Yes.
Okay, so you understand the oath?
Yes.
You understand the gravity of perjury?
Yes.
When was the last time you spoke to Mr. Lally before Friday when you began testifying?
Before Friday, the last time I spoke to Mr. Lally was, I believe, on a conference call around the time of my grand jury testimony.
Which would have been
Okay, so a couple things, because people want to quibble online. I tweeted a couple times today, and in this case, that's very dangerous to do. Casey said she's been watching all week, had to become a member from Boston, but really enjoy this unbiased look at the trial. Casey, thank you so much, and welcome to the membership crew, you and all the other new members tonight. So people are quibbling about him misunderstanding. And as a lawyer, I can understand how maybe you think, oh, it's not that big of a deal. He asked if he spoke to him. He said no. Those of you that watched the trial this morning already know where this is going, but he did something there that experienced witnesses do. They repeat back the question the lawyer asks, because that does two things. It lets them think about the answer and buys some time, but it also makes sure they answer the question precisely and don't give too much information. So he said, when's the last time you spoke to Mr. Lally, the prosecutor? And he said, when was the last time I spoke to Mr. Lally? It was before my grand jury, right around the time of my grand jury testimony. Okay? Months ago. And we're going to confirm that here before we realize what a big oops this was.
2022?
Yes.
April of 2022?
Yes.
You've not spoken with Mr. Lally since that time?
I don't remember speaking with Mr. Lally since that time, no.
What about anybody?
So again, April of 2022. Yes, that's when you spoke to him. Yes. And you don't remember speaking to him again outside of that time? No, I don't remember speaking to him again out of that time. Now, if I'm Mr. Lally and I'm sitting over there, I'm starting to sweat. I'm like, oh, dude, what are you talking about? We just talked a couple weeks ago. Because that's the answer. They just spoke a couple weeks ago. And knowing that answer, how does that make you feel right off the jump? You just had a great day testifying on direct exam. You start your cross and immediately you say information that's not correct. I'm not going to say he lied because I don't know that he did it purposely. And he corrects it pretty quickly here. But as a witness, you're like, crap. This wasn't even one of the things that I thought was going to be a tricky question. But he couldn't have been clearer that he has not spoken to Mr. Lally since April of 2022. It is now May of 2024. That is 2 years, which would be wild to not prep for your trial testimony. Everybody preps for their trial testimony.
Anybody else from the district attorney's office?
No.
Have you gone over the facts, or what you believe to be the facts of your testimony with anybody before you testified on Friday, not including any lawyer that you may have?
No.
And once again, people are quibbling like, well, he confused the difference between speak and prep. If he would have asked if he would have prepped, then he would have said yes, but he said speak to Lally. It's like, no, he basically defined the conversation of preparing for this trial and talking about the facts of this case, which is exactly what you do with the lawyer if you're a witness and you're preparing for trial. I mean, this is bad. This is bad. Lawyer or not, like I think to a lay person, to a lawyer, it's like, yeah, we know witnesses prep. We know the prosecutor prepped this witness. And I think Jackson was probably a little surprised because he's like, holy crap, he's going to say no to this? That's impossible, right? He literally defines it as talking about the facts of this case. And he says no 5 different ways and times. He says no.
Did you discuss any questions that you may be asked on direct examination or questions that you may be posed on cross-examination with any member of the district attorney's office?
No.
Were you told about?
I mean, I don't know how he could have confused speaking for prep at this point. Did you discuss the facts? Any questions you may be asked on direct? Any questions you may be asked on cross? He's defining prep for this trial. He is defining that. So it's not just like, did you speak to him in the hallway? That's not what he meant.
Any exhibits or documents that you might be shown?
Just in the prep, I believe I was shown a video of the waterfall bar.
And that was back in April of 2022?
No, that was for the prep for this trial.
With whom did you prep?
I promised Lally,
I'm confused. I thought you said you had not spoken with Mr. Lally since April of 2022.
except for the prep for this trial. I had not.
And again, as an experienced witness, I really think that he realized his mistake and then flipped it into prep, because this was not trick. This was not a trick. It wasn't a tricky question. It wasn't like something Jackson was trying to do to, hide the ball. He was just trying to tell the jury, I think this all stems from he did a good job on direct. So it's like, you did a good job because you've testified 100 times and you prep with the Commonwealth, right? That's what I think Jackson, that's all Jackson wanted to get. I think he expected this to be quick, but I was like, wow. And I do think that this is an indication Brian Albert's maybe a little nervous.
Okay, that was my question, Mr. Albert.
Okay, I misunderstood your question. I apologize.
Did you prep for this trial with Mr. Lally?
Yes.
When?
Approximately a few weeks ago.
Okay, Mr. Albert, about 45 seconds ago, I asked you, have you spoken with Mr. Lally before your testimony in this process, this proceeding? And your answer was, no, I have not. Did you not understand my question?
I did not.
What was confusing about it?
I was expecting you to ask if I had prepped with Mr. Lally. I didn't hear prep with Mr. Lally, so I didn't know what you were referring to.
So when I said spoke with Mr. Lally, since I didn't say prep with Mr. Lally, your answer was no, I didn't speak with him. I just prepped with him.
Yes.
What's the difference between speaking and prepping?
No, there is no difference. I just misunderstood your question. That's all.
Tell me about that prep with Mr. Lally.
Sure.
I mean, Jackson could have gone a step further and been like, what about when I defined it about the facts of this case, the questions you may be asked? Like, none of that rang a bell for prep, but I mean, you don't want to go too far, which just hold on. So I think he got his point across. I think it was a bad start for Albert, and I think he's now on his heels right off the jumping cross. We're going to listen to a lot more of it. John, it was pretty wild. It was pretty wild. And I think there were parts that the defense crushed and other parts that maybe not. RS 6 months member today. That's awesome. Cause I farm. If the Alberts are so innocent, then why do they all have lawyers? That's a lot of money to spend if nothing happened and Brian was never in the house. So you'll never hear me condemn somebody for hiring a lawyer. I think it's what everybody should do if there's even a sniff of a problem or somebody's accusing you of something. And it's very clear that some high-powered attorneys are accusing them of crimes. So I think they did the right thing by getting an attorney personally. Margaret, Brian Albert came across very evasive, and both he and Higgins getting rid of phones and saying too many coincidences, house, dog, phones. All right. So I'm going to hold on any more comments because I don't want any more giveaways. Four Cats, lawyer, why does it feel like both sides are just fighting each other and not trying to prove a case? So this has been a very common question and comment throughout this case. And this is a huge win for the defense. If both sides just feel like they're fighting each other and neither side is proving the case, that's a win for the defense because only one side has to prove a case. I don't disagree with you. That is what it feels like. And we're going to hear more of that in today's video. Rebecca, thank you for welcoming 20 new members to the Lawyer You Know membership crew. All right, let's keep listening now to what actually happened in that prep with Mr. Lally.
I prepped with Mr. Lally about this trial with Mr. Lally, my attorney.
Where did that preparation take place?
The preparation took place, I believe, I'm trying to remember exactly where it was. I actually don't recall where it was.
Could it have been at the DA's office?
Yes, but it wasn't at the DA's office. No, I believe it was somewhere else, but I can't remember if it was here at the DA's office. I'm not sure.
I also asked you a couple minutes ago, did you review any documents or any evidence in preparation for your testimony? And to that question, you also answered no.
But I said I reviewed the video.
Well, now you're saying you reviewed the video, but when I
Yes.
asked you, did you see any evidence or documents, anything in preparation for your testimony? You said no, right?
No, I believe I said I saw a video.
Did you understand? Did you
Actually, I think the defense attorney's wrong there. I think that's when he figured out just during the prep is when he said that, when he showed him evidence. But he said, did you talk about the facts or questions? Then he said, no, I believe. I could be wrong.
understand my question when I asked it the first time as well?
No.
Okay. I'm going to try to be clearer with my questions.
Okay.
Let me try it again. What, if anything, have you reviewed in anticipation of your testimony in this trial?
So I reviewed a video of the waterfall.
Anything else?
I reviewed my transcript from the grand jury.
So you have reviewed your prior testimony,
My transcript of the grand jury, yes.
which is prior testimony, correct?
Yes.
When did you do that?
I did that during the prep.
All right. And that's important because there's going to be more of that later. Margaret, you do not need to apologize. That's on me. Usually I try to preview the comments before I put them up there for the most part. And that's on me. And most people here have already watched it. So it's not really a spoiler alert. No need to apologize. So then we're going to jump ahead a minute to some discussions I believe he had with Higgins is this next part.
Bar instead of drinking, correct?
Yes,
Do you have anything to eat at the hillside?
I did not.
But Brian did. Brian Higgins did.
I left prior to Brian Higgins eating.
During the course of that road trip, or at the hillside, did the two of you discuss Karen Reed, my client?
No,
Did her name ever come up?
no,
Without telling me anything that he may have actually said, did he mention Karen Reed or the topic of Karen Reed?
no, never.
Did he mention the fact that he'd been texting and flirting with Karen Reed 2 weeks prior?
No,
So that subject, according to you, was never addressed or broached by Mr. Higgins or you
no,
during that entire day?
no.
After you arrived at the waterfall, John O'Keefe arrived.
Brian
Sub-
Higgins and Karen Reed were flirting via text. Do they have evidence of that? I'm interested to see. He says, it didn't happen. He doesn't know what he's talking about, but are we going to see those text messages? Is Karen Reed going to say that he was flirting with her? Is Brian Higgins going to say he was flirting with her? I don't know. These are the kind of indications that make me think Karen Reed might testify.
Went there too, right?
Yes,
How long after?
approximately 45 minutes, maybe.
And Karen Reed was with him, is that right?
Yes,
Brian Higgins was standing right next to you when she came in along with John O'Keefe, correct?
I'm not sure where people were standing when they arrived.
Well, you remember you saw video, correct?
I don't believe there's any. I saw video of them walking into waterfall now.
Fair enough, but you saw at least a clip, according to you, saw a clip of that video of you at the waterfall, correct?
Yes,
You were situated at a high top table, right?
yes.
Your back is sort of to the camera, is that right?
I'm not sure of the camera angles. The video that I saw, I was at the high top table, but I'm not sure of all the camera angles of the waterfall.
All right. He goes on to describe him and John O'Keefe's relationship as kind of normal, coworkers, nothing close. He respected him for what he did for his family. Definitely better friends with Higgins. They keep referencing this non-Commonwealth hearing where the defense attorneys aren't there, the Commonwealth's not there. You guys know, this is one thing that I did know happened outside of this trial is the federal investigation. I've not dug into it too much. I know it exists, and I know that's the other hearing that they're discussing. And it's very interesting for the jury to hear about a hearing that the Commonwealth was not there at. And I think the defense wants the jury to know the Commonwealth wasn't there because they're going to say that's where these witnesses were more honest and were not necessarily prepared as much for the Commonwealth and weren't spoon-fed questions before they testified, which is very interesting. And we know some impeachment's coming whenever they do things like that and set up that prior testimony. He starts to say, and here is something where you guys might not agree with me. Okay, so get ready, listen up, get your typers ready. They get into Brian Albert and how well he knows or could recognize or has spoken to Karen Reed in the past. He said the woman originally looked like Karen Reed, but can't say it was her for sure. It was a vague knowing of her. Then at the Lowley grand jury, he told a different story. He said he never met or had seen her before. And I thought it was a big deal that he even said he read through his grand jury testimony prior, so he should know what he said. He didn't know what he said. It's very strange. And I thought Jackson had him by the you know what. I was like, oh, baby. So one time you say it was her, then in the Lowley one, you say you never seen or heard of her? What? But then we get into the actual full quote from his grand jury testimony. And I want to know from you guys. I really want to know from you guys. Do you think this was a lawyer twisting words or wordsmithing or, slimy lawyering that we get accused of doing things, taking people's statements out of context, taking part of a statement and not all of it? Or do you think it was fair cross-examination and impeachment that Alan Jackson is taking one statement saying it was a woman that looked like Karen Reed. I can't say it was her for sure. And then we'll also talk about how, they had been at a bar together a few days prior. And then him saying, never met or seen her or heard of her before. But then he finishes the sentence. And let's watch this exchange.
Brian Higgins is the guy with the sweatshirt.
Just kidding.
Maybe a hard
Skip ahead to this part yet.
Does that refresh your recollections to what you said before the grand jury in April of 2022?
Yes, but you didn't read the whole quote though.
Right. The whole quote is the following.
And by the way, another indication of an experienced witness is he remembers what he says. And when he reads something and a lawyer didn't read it off precisely, he's going to make you know about it. And that's also why citing exact page and line numbers of prior testimony, whether it's deposition at a hearing, whatever, is so important for lawyers. And Alan Jackson did not make a mistake. This was exactly his plan. He wanted to use the quote exactly like this. And I think he did use it the way he wanted to. Just to me, because of the disagreement and the back and forth, it lost some of its sting because there was this second part of the quote that Brian Albert made sure everybody heard. And I hate to think if I'm a juror and I was like, man, if Jackson would have never read the second part of that quote, would I have felt like I really got the full quote?
Question. So the female you had never met before, is that fair to say? Answer. No, I've never met her or seen her before, period. Maybe once, but I don't think I've ever had a conversation with her. That was the entire quote, correct?
That's the entire quote. Yes, that's not what you read earlier, but yes.
Well, what I read earlier was, I've never met or seen her before. Those words came out of your mouth, correct?
That's not my whole sentence. No.
You said, I've never met or seen her before. And then you said, maybe once, but I've never had a conversation with her, I don't think.
Right. That's my sentence.
Okay, so which is it, Mr. Albert? What were you saying? Were you saying you met her and had a conversation with her? Or were you saying, I've never met or seen her before? Which one of those two things was true?
I was saying that I've met her maybe once.
Actually, what you said was, I've never met her or seen her before. Your words, not my words, sir. Isn't that right?
No, because in the next sentence I say I met her maybe once.
So you literally changed your testimony within your own testimony.
Objection.
No, can you answer that, Mr. Albert?
I believe I qualified my first sentence with a second sentence.
So what changed between the first sentence, where you indicated unequivocally, I've never met or seen her before, and the second sentence when you said, maybe once?
I'm not sure what I was thinking at the time that I said that.
Isn't it true?
So I kind of agree with the way Brian Albert is qualifying it and saying it. He did say both, but it's kind of like, I never seen her before, met her before, maybe one time, but I can't remember. That's not, saying without a doubt, I don't know who she is. This is just my opinion. Okay. Just my opinion. I thought he crushed him in the beginning of cross. This one, I think they went back and forth way too much on this, for what the actual quote was. Just one man's opinion.
True, Mr. Albert. Not only had you met Ms. Reed, but you had spent several hours with Karen Reed and John O'Keefe 6 days before this incident. Is that true?
No.
In fact, on January 22nd, 2022, 6 days before January 28th, you socialized with Karen Reed at the Hillside Bar for several hours, didn't you?
I was at the Hillside Bar the week prior, yes.
It was a Saturday night, correct?
Yes.
You were at the bar?
Yes.
There were several other folks at the bar, correct?
Several people, yes.
That included Chris Albert, your brother?
Yes.
A guy named Tim Daly?
Yes.
D-A-I-L-Y, is that right?
I'm not sure how to spell his last name.
Julie Albert was there?
Margaret, this is kind of my thought too. I saw where he was going 100%. I got it. I think it made sense, but I do think he maybe dug it in a little too much. And then we do see a picture here of them at the bar, and it is two Alberts, I can't remember, Tim Daly and John O'Keefe. And the defense lawyers push pretty hard that they think Karen Reed is the one who took this picture. I think they made some good circumstantial points that would make you think that. And it makes sense, but he definitely, now here's the thing with Albert, and this is also why I thought Jackson is crushing on cross. Okay. He's incredibly fun for a lawyer to watch him do his thing on cross. Okay. So anything negative I say about the cross, I'm just nitpicking because that's what we do is we talk through what lawyers do and happens in trial. So I want to qualify it with that. See, that's a qualification. But I think that it's very clear and obvious that Brian Albert's evasive testimony, discussions about John O'Keefe and Karen Reed, it was absolutely positively he was trying to distance certain people, including himself, trying to act like people weren't there or people weren't involved. And then, oh boy, do we get a truth bomb when we start to go through who he called, when he called them, and how often he called them later on in the cross-examination. And then they go over that quote again. It was like, oh, your initial immediate response is that you didn't know her, you never saw her. And he really tries to hammer home on that. And then he just kind of asks him straight up, you want to distance yourself from Karen Reed. Isn't that true?
Your grand jury testimony with, well, I'll use the dates, in your April 2022 grand jury testimony, weren't you?
No.
You were further trying to distance yourself from Ms. Reed in your June 2023 grand jury testimony as well, correct?
No.
You thought that it was important to try to deny knowing John O'Keefe and Karen Reed during those interviews and or that testimony.
Objection.
Sustained.
Mr. Albert, you knew that if you admitted having a relationship with John O'Keefe and Karen Reed, you'd have a lot to answer for when Karen Reed's boyfriend ended up dead on your lawn 6 days later, correct?
Objection.
Sustained. You can ask the question differently.
You knew that there would be questions about your relationship with Karen Reed if it would not know that you knew her before her boyfriend ended up dead on your lawn 6 days later, correct? There would be questions.
Objection.
You can ask it a different way. That's sustained.
So Azam, I'm not sure if she was able to watch. She said she was going to be with her students, but she asked me, why does the judge say you can ask it a different way? Some judges say you can rephrase that, or if you rephrase it, you might be able to ask it. I actually think it's the judge throwing the lawyers a bone when she says that, because she's saying sustained, but saying you can still ask about that content, just ask it a different way, as opposed to move on, or you can't ask that question, or whatever it may be.
So you lied under oath when you said, I've never met or seen her before, correct?
No, because that wasn't my whole statement.
The sentence, I've never
This is
met
like the 5th time he's gone back to this quote, I think. Literally like the 5th time.
or seen her before. Pretty unequivocal, isn't it?
That was not the context of my whole sentence.
But that's the words that came, those are the words that came out of your mouth, right?
Initially, and then I remembered that I had met her once.
Let me just ask it this way.
Sure.
Is that sentence true or false? That you had never met or seen her before? True or false?
That portion of that sentence is false.
Let's get this on the record. Did John O'Keefe come into your house at 34 Fairview at any time on January 29th, 2022?
Absolutely not. I wished he had.
And you're as sure about that as you are about the statement that you had never met or seen Karen Reed in your life,
Objection.
correct?
Sustained. You can ask it differently, Mr. Jackson.
I want to get back to the waterfall.
So, and that's a stylistic thing. In case you haven't noticed, they love to impeach them on a statement, say you're really sure about it, and then when there's a fact that they don't like, they say, "Are you as sure about that fact as the fact you were wrong about when I impeached you?" And I think it's pretty effective, and it's pretty cool when it goes right. What Willie thinks. No longer my client, it's Karen Reed. I agree. The defense lawyers have done a lot of that, and he always says the defendant. Other witnesses, you could tell they tried to do it, but then once they kind of got rolling, they would call her Karen, Karen Reed, Miss Reed. They would call her by her name, but I've been picking up on that too, what Willie thinks. Lorraine said, why can't he ask certain questions? So there's evidentiary issues. If you ask questions the wrong way, you can't ask about hearsay. You can't be argumentative. You can't ask witnesses to speculate. So there's all sorts of evidentiary reasons he can't ask certain questions the way that he's asking them. But if you ask them a different way, same thing on direct, you can't ask leading questions. So you might be able to ask, was there anything in the house versus you found a couch in the house, right? Things like that. Different ways to ask questions can make them admissible. Okay. So then he starts asking about the waterfall. And did Brian Higgins get upset when Karen Reed and John O'Keefe showed up together? Very clearly trying to set up. Higgins liked Karen Reed, flirted with her, was mad when they showed up. And then he talks about the fact that he drove the black Ford Edge to the waterfall, the black Ford Edge back home. Colin and Brian and some young kids were there hanging out at his house. He didn't tell them about that. He didn't tell a lot of people about that in interviews beforehand. And let's hear what he has to say about something that's been very important on these first few days, which again, a lot of people are saying it's been 10 days. Why haven't they proven anything? I don't understand why it's taken so long for the prosecutors to get into anything. Like Amy, why isn't the judge admonishing the Commonwealth for being repetitive, very repetitive, questioning these witnesses? They've gotten nowhere in 2 weeks. I got to be honest with you, Amy, that's pretty much what my notes look like. As I'm listening to this, and I'll pop over and make a note every once in a while, I'm like, well, same background for another Albert. Who were you? Where are you? Who's your sisters and brothers? Where do you live? Where do you live now? What time did you get to the waterfall? Who was at 34 Fairview when you showed up? So much of the same question. What was the weather like outside? Who left when, et cetera, et cetera. It is important, but for the fifth time, I think it's almost creating fodder for the defense to cross-examine with. But what was really important early on was this conflict of interest issue. And so let's hear Brian Albert's take on it.
On the morning of the 29th to Michael Lang, about 7 a.m., is that right?
Officer Lank was in the house at that time and speaking to all of us, really.
And you've admitted that you have known Michael Lang for many years, is that right?
Yes.
Did you see that as a problem?
In what way?
Conflict of interest?
Objection, Your Honor.
I'll let him have it. Did you see that as a conflict?
No.
You were asked who was
Of course, I mean, I hate to say this, okay? I love a lot of cops. I love a lot of cops, a lot of good cops. I have some really close friends that are cops. But it's like asking a cop if it's a conflict of interest for him to investigate or question a person he knows, pretty sure he's going to say no. I mean, it seems like an obvious conflict to me.
present at the house that night, the night before, right?
Yes.
You stated the following people were at the house that night, quote, in response to,
And I don't mean a conflict as in like that cop can't do anything, but maybe somebody else be there. Maybe somebody else ask the question if you can. If it's the only cop in a small town, he's going to know everybody. I get it. But another cop that you work closely with, their family member, there's just way too many connections here, in my opinion, based on especially Lank's past with Chris Albert, for this not to be a conflict.
Mr. Lank's question at some point during the time in question. That's how he phrased the question. Who was at the house at some point during the time in question? You understood that, right?
I don't recall his question, no.
You knew that he was asking who's in the house.
That's right, yes.
So you mentioned Brian Albert Jr.,
Yes.
your son. You mentioned Caitlin Albert, your eldest.
Yes.
You mentioned Julie Nagel.
Yes.
You mentioned Brian Higgins.
Yes.
And then you added the detail that Caitlin Albert had left your house about 12:15 a.m., correct?
No,
You didn't say that?
I did not.
I may have just a moment. Yes.
So this is really important because the defense wants to impeach his credibility, basically saying throughout this process, you've been trying to protect Colin and Caitlin. That's their theory. That's their line of questioning right here. And one of the ways is you said she left at 12:15. Very clear she didn't. She's about to testify and said she left at 1:45 or 2 a.m. He's like, I didn't say that. It's like, what? You didn't say that. Hold on. Let me get Lank's report of these interviews. Bean Man Road Glide. How can you agree with Brian Albert? He's lying. He backtracks and stumbles his statements. He's not police. He's not police. He's a gangster. BPD is a gang. Okay. So this is the risk of disagreeing with, what the public kind of thinks about a case, which I get it. And I think I'm kind of in line with that so far. There's a lot that can still happen, but I didn't say I agreed with Brian Albert. I agreed with the way he qualified his statement that Jackson read part of the statement and left out the very next sentence that does give context to the first sentence. That's all I meant, is that I do think it's fair to read that second question. And if it gives more context, the jury should hear all of it, not just the first sentence. That's all I agreed with him there on that statement on. That's what I meant by my agreement with Brian Albert. So I was qualifying my agreement there. So Jackson is going to get the interview with Lank and give it to Brian Albert to refresh his recollection about what he said in that interview.
Albert, did you have an opportunity to review that portion of a report?
I did.
Did that refresh your recollection about conversations you had along with your wife with Officer Lank?
Yes.
Isn't it true that Officer Lank asked you and your wife who else was in the house that night, aside from the names already mentioned? And the names mentioned were Brian Albert Jr., Caitlin Albert, Julie Nagel, and Brian Higgins, quote, who was a friend of Brian Albert Sr., end quote. Is that right?
That's what the report says, yes.
And then the report goes on to say, they advised me that their daughter Caitlin left the house around 12:15 a.m. when she was picked up by her boyfriend, Tristan Morris. Right?
That's what the report says, yes.
Do you think Officer Lank got it wrong?
Perhaps, yes.
Did you say that Caitlin left about 12:15?
No.
Did Nicole say in your presence that Caitlin left about 12:15?
She did not.
At any point, did Officer Lank ask you what time Caitlin left?
I don't recall him asking that. It was a very chaotic morning, and I don't remember him saying that.
So in fact, if he wrote that sentence in the report that you just read, he's just making that up.
Objection, Your Honor.
Sustained.
I'll ask it a different way. If that's what Officer Lake recalls, he's just wrong, right?
Yes.
That's what you call a win-win for the defense. When you got this guy on the stand and you got a statement that's obviously dead wrong that you're planning on impeaching him with, and he says, no, I didn't even say that. It's like, oh, well, even better. Instead of just impeaching your one statement, now I'm going to chip away at the credibility of every statement Officer Lank took. Because if he's just putting categorically incorrect and false facts in reports about interviews that he didn't record, can we really believe any of the facts that are in his interview? And this is a cop, a strong witness, saying he got it wrong on my testimony. I mean, that's almost, I would call that a bigger win for the defense than if he would have just said, yeah, I was wrong about that. They do push and say they think he's trying to cover up for Caitlin and Colin. And here's where some of the interesting parts start coming. We're going to have a little bit about Chloe here in the middle, but he goes over to Jen McCabe's house for her interview. He has no real reason to be there. He was there for her entire interview, and she knew he was there. As you know, the big, scary cop guy, family member, he's known her since she was 6, like his sister, but also like, you better not snitch on my kid or my nephew or whatever it may be, which is what the defense is trying to push. And it's like, I don't know John O'Keefe. I barely know Karen Reed. We're barely friends. It happened in my yard. I didn't go outside because there was nothing more I could do. But yet you're over there for those interviews the whole time. You don't let her out of your sight when she's being interviewed. He doesn't remember he or Higgins going in the basement. And then we start getting to Chloe, who's not great with strangers. She barks only sometimes, not all the time, when she sees new people. And the defense is going to dig into the rehoming story again.
April 2022. So I let it go out to the bathroom. I let it back in. I kind of monitored it a little because we usually don't have people over the house, and the dog's not great with strangers, period. So I was just making sure that the dog was all right with the people that were over, end quote, correct?
Yes.
So in fact, you did keep Chloe downstairs, at least for a period of time, with people that were over, right?
Yes, for a few minutes, I think.
Mr. Albert, after you learned that there were questions being raised about John's injuries and dog bites and scratches, in May of 2022, you got rid of that dog. No?
Objection.
Sustained. You can ask it differently.
At some point, your family got rid of Chloe.
Chloe was rehomed in May
And we can use
2020.
whatever words we want to. Rehomed, rehoused, whatever. But you got rid of her. She's no longer part of the Albert family, right?
Objection.
Allow that.
Right.
I thought that was a key, important moment for Jackson, the defense attorney. He's like, use whatever word you want, dude. She's out. She's not with the Alberts anymore ever since this happened. And he eventually says yes. And the judge let him ask that question. That could have been sustained as argumentative. But I'm so happy he said that, because don't let witnesses pacify or change the verbiage to try to change the meaning of what happened. And the point is, this happened and she was out. This happened and they sold their house. And something else was rehomed that we're going to get into later. But I'm glad he did this. Caitlin Johnson, not Caitlin Albert, said it feels like the Alberts are on trial as they're spending so much time quibbling and parsing words. They all seem like they're hiding something. Well, again, this would be a win for the defense. If the jury starts trying to figure out whether or not the Alberts did it or which one of the Alberts did it, guess what? That means they don't think the Commonwealth proved beyond a reasonable doubt that Karen Reed did it. Amy McIntyre said, does being a passionate lawyer have a negative effect on the jury? I think it all depends on a couple of things. Number one, depends on the juror. But number two, it depends on the way your passion comes out. I don't think anything these lawyers have done outside of maybe beating a dead horse once in a while has really done something to make it negatively reflect on Karen Reed. There have been other lawyers in trials that know the way that they lawyer and their passion and their arguments sometimes reflect negatively, and they don't want that to, and they'll tell the jury that. If you don't like me, don't take it out on my client. We've heard that before. So I really think it depends on the case, the lawyer, and the jury, of course.
When did you get rid of her?
So Chloe was rehomed in, I believe, May
Of 2022,
of 2022.
just months after the incident we were discussing.
Well, after she was involved in a dog fight with another dog out front.
Right, but that's also after the incident we
Yes.
were discussing.
Yes, May.
That's a family pet that you had for 6 years or 7 years.
Approximately 6 or 7 years. Not
Your
sure.
explanation just now for having gotten rid of that dog is because it bit another dog and ultimately sent 2 women to the hospital, correct?
I believe 2 women went to the hospital. Yes.
But you took no action to get rid of Chloe until after you knew that serious questions were being raised about John O'Keefe's,
Objection.
correct?
Sustained.
At some point, you did realize there were questions being raised about John O'Keefe's injuries on his arm, correct?
Objection.
I'll allow that. Did you realize that?
I heard some talk about it. Yes.
This is also a huge point. So the other thing is I thought the cross was a little bit long, and some of these really great points, if they don't have somebody going back and pausing and talking about them and highlighting them, maybe some of them got missed. But he just got him to agree that they got rid of the dog right after they started hearing some rumblings about the injuries to John O'Keefe's arm and how they may look like dog injuries or something that happened from a dog. Bill Smith, by the way, I have your theory, your 4 parts queued up, but I'm going to wait until after to play them. So no spoilers, but that's so we can talk about it. What really happened kind of questions, and we'll talk about that at the end. But I thought this was a really great point by the defense.
As of January of 2022, John O'Keefe had never been in your house, had he?
John O'Keefe was never in my house before or after that date.
Certainly, John O'Keefe, you would agree with me, he would count, or in your house, he would count as a stranger to Chloe. Never met him.
Hypothetically, yes.
I want to ask a couple of questions about your house.
So they go to the layout of the house again. One part I did think was interesting and a little bit different this time was we got a little bit about the basement layout.
It's a relatively quiet street generally, Fairview.
Yes.
Not an enormous amount of through traffic.
No.
Not a busy freeway or highway, correct?
No.
Not an especially noisy street,
The street, no.
especially at 6 a.m. on a Saturday morning, right?
Right.
Where were you at 6:03 on the morning of January 29, 2022?
I was sleeping in my room.
6 feet from that window.
Yes.
Was Nicole in bed with you?
Yes.
Had you taken any medication the night before?
No.
Were you on any sedatives?
No.
Hold on. These are some of the questions that you all had that I thought were amazing during Nicole's testimony, during his direct. Why didn't anybody ask if he had a sleep mask on, or if he had earplugs in, or if they had a noise machine, sleep apnea, whatever it may be? Why didn't anybody ask those questions? Because if that was the case, then maybe that's why they didn't hear any of the commotion. And maybe the Commonwealth didn't ask the question because they knew the answer, which they don't have to ask it. But guess what? The defense is going to ask, and the answer is going to be no to all of the above. No medication, no issues, no mask, no earplugs. So again, how the heck did you not hear all the commotion prior to 6 whatever a.m.?
Sleeping pills?
No.
Were you wearing a sleep apnea machine?
No.
Were you wearing an eye mask?
No.
Were you wearing earplugs?
No.
You shortly thereafter became aware that 6 emergency vehicles, including a fire engine, police cruisers, and unmarked police vehicles, a civilian SUV, were all parked in front of your house that morning, correct?
I'm not aware of what type of vehicles were parked there, no.
You've seen photographs since this incident?
Of the vehicles out front?
Right.
No.
Are you aware that all of those vehicles had their engines running?
No.
Are you aware that all the emergency vehicles at least had their lights on, flashing lights?
No.
Were you aware that there were first responders outside their vehicles traipsing around your lawn?
Was I aware?
Were you aware at the time?
No.
Were you aware that there were emergency responders, first responders, who were talking to each other over the din of the wind and the snow?
What?
To communicate with each other?
No.
You're aware that there were 3 women on your lawn at one point?
Just only after the fact.
And at least one of those women was screaming to the top of her lungs at 6:03?
No.
Again,
That's why, by the way, and this is why cases build, because I didn't really know where they were going with some of this. You guys may have, because you know a lot more of the background before the trial started. But that's why I think they kept repeating, she was hysterical, she was screaming, she was repeating, I hit him, or he's dead, or is he dead? Whatever it was, the quote was, they got every witness to say she was screaming it hysterical over and over again. Luz, I agree, and I kind of thought this too, except that none of them have said that. So I don't think this is a fact and evidence that they were actually drunk. But I mean, obviously, this was something that probably popped into all of our minds. John said, Peter's original promotional statement, can you trust a lawyer? These lawyers are word experts and seem slimy and defensive, right or wrong. Where does respect lie? I think John likes to play devil's advocate. I think there are 2 ways to see a lot of this, and I don't feel like they've been very slimy at all. I think that was an interesting impeachment.
your German Shepherd was 6 feet from the window, correct?
I don't know that for sure.
That's where Matt was.
Well, that doesn't mean that's where she always is. She also sleeps in the closet area sometimes.
Oh, so now Chloe's in the closet.
I didn't say she was in the closet. I said she sleeps in the closet area sometimes.
Is she sleeping in the closet area that morning?
I don't remember.
Likelihood is she's sleeping on that mat 5 or 6 feet from that window, correct?
Judge, I don't know.
And your explanation, and by the way, we've already talked about this. Earlier that day, you already indicated she was barking because she heard people and noises downstairs when you guys came in the house.
Yes.
And your explanation is that you and Nicole and Chloe, the German Shepherd, all slept through the entirety of that commotion on your front lawn.
Yes.
And he says it with a straight face and no problem. There's a couple of rhetorical questions like this from Gringa that I'm going to put up there that you guys can see and look at. Somebody said, so Lady Los Angeles said, Peter, hope for more from Cross. Why fell short? Exciting news. I'm now helping a PI firm attorney, even in court, research and discovery. Grateful for your be a lawyer shorts. Us students need it. That's awesome. Congratulations, Sandra. I think there's a couple reasons why, if you felt like it fell short, I would not say it fell short. I think it felt a little bit long and there were some swings that missed, but I think it was great. I think he got a lot of great information, and a lot of people, I think, if you wanted to see that Brian Albert was hiding things or being evasive, I think you got that out of this cross. But I think it fell short at times, or if you feel like it fell short, the reason might be he's a experienced witness. He's not afraid to say something. He'll correct his statement. He stays calm. And I think if you're the defense or you're somebody that thinks he's lying or has an agenda, doesn't seem like he has a problem saying whatever he needs to say with a straight face, right? Not a lot of tells from this guy if he's telling something that's true or false. I'll just kind of leave that one there. Brooklyn Basement, can Albert get in any trouble for the phone? I will save this till we get to the phone. Selena said, when are we going to see strong evidence by the prosecution? Hopefully soon. They're laying a lot of foundation, but hopefully we see some real dot connecting here soon. I said we were going to hear about the basement. I jumped the gun on that a little bit. Now we're going to hear about what was in the basement.
What was the basement used for in January of 2022?
So the basement had a weight room in one of the rooms, and the other room was nothing at the time. It had been damaged, or water damage through an overflowed toilet.
So part of the flooring had been ripped up.
Yes.
And that opened up some slab concrete downstairs.
Yes.
There was also some plywood downstairs.
Yes.
There were a couple of mats where the actual weights were, so they're not slamming down onto concrete.
Yes.
But there was a good amount of that floor that was just exposed concrete.
Yes.
The workout equipment would include things like what? Barbells, dumbbells,
Yes.
heavy weights,
Yes.
heavy bars.
Yep.
Made from metal.
Yep.
Once you're down in the basement, by the way, there's 2 flights that you go down at angles to get to the basement. A series of steps, a landing, take a left, another series of steps, and you stand on the basement.
Yes. Not a long staircase, very small, but
Right. I mean, it's narrow and tight, but in other words, you don't just walk straight down a staircase. You go down to a flight, to a landing, turn left,
turns a little.
go down, turn left again, and now you're in the basement. If you were to move something large or heavy out of that basement without having to go through that
Alan Jackson has some great suits. I mean, the tailoring is just, they just fit him perfectly. I love a nice tailored suit.
house, to do that.
Objection.
I'll allow it.
Could you rephrase the question?
I'll say it again. If you wanted to move something large or heavy out of that basement without having to go through the main house, could you do that?
Yes. I mean, it would depend what it was, obviously, how big it was, or
How would you do that?
there's a bulkhead door you can use.
Got it. Where does that bulkhead door come out?
It comes out to the backyard right at the kitchen area. You can see it from the kitchen.
And right to the left of that is the side fence.
Yes.
So eventually, after a break, there is a little video. It gives you an idea. So this is what it looked like from the basement looking out at the bulkhead doors. Is that what they're called? I don't even know. We don't have basements in Florida for the most part. And then there is this is video from the outside looking down. And then they play a little video
Now you
of them walking from outside the basement to where John O'Keefe's body was found. You walk right out of the basement, you make a left. Obviously, the defense is trying to set up. This is what they did. They took his body from the basement up the bulkhead door so people wouldn't have seen him maybe. There was no footsteps over on that side, and walked him around the side of the yard, and this is where they put his body. I think what they're trying to get the jury to believe at this point, because KZ, he said, wondering what the jury's thinking at this point. Yeah, there's no way to really tell. But I thought that was a pretty good demonstrative, if that's what they're trying to do. I don't think it really proved anything. But again, it definitely feels like the defense is at least trying to prove things more than the prosecution is. We stop. They do a little voir dire on when he got a lawyer. And I think it was like, what subjects can they get into or not get into? The judge ends up allowing the line of questioning. And this is where we get to the phone debate. Okay. He doesn't agree that he got notice on whatever day that the defense says he got notice, and he ends up getting an upgrade, or as I made the joke on Twitter, rehoming his phone the day before he was given notice from the Commonwealth, who he's supposed to be helping, to keep that phone, preserve that phone, do not destroy that phone. It could be evidence. And just so happens the day before, I'm not saying any of his buddies tipped him off to it, right? But the day before, he upgraded his phone, and as the defense is going to say, got rid of his phone. What's interesting as far as lawyering on this part that I enjoyed is asking these questions. There's no real good answer that Brian Albert can give. So when you have that as a lawyer where the witness really can't give a good answer, it gives you confidence going into it. And he let Brian Albert answer however he was going to answer, because he knew that he had what we call a stipulation that he could read to impeach Brian Albert. What's a stipulation? It's something both sides agree to. So the defense and the Commonwealth both have agreed to a fact that can be read to the jury at the appropriate time, which is now. And what did they stipulate to after Brian Albert would not agree that he was given notice the day or 2 days after he upgraded his phone that he needed to preserve his phone?
Or September 23rd. Now, yes, I would offer the following stipulation that on either September 23rd or September 24th, the Commonwealth sent a letter on Commonwealth letterhead to Mr. Albert's attention, stating exactly what was just read into the record pursuant to the court order dated September 23rd, 2022.
Okay.
So it is a stipulated fact that he was, in fact, put on notice or sent that information on, I think it's the 22nd or the 23rd. And he got rid of his phone on the 21st. And that was the question I think Brooklyn Basement had about, can he get in trouble for this? So the answer is no, because it wasn't pursuant to spoliation letters, what we call it in Florida, or preservation letters. It sounds like what they call it there. There was no court order to preserve his phone. Now, theoretically, if you're on notice that litigation is coming and you destroy your phone in Florida, there are rules that you can get in trouble for that. It doesn't seem like he got in trouble for it here. And there's more context coming that I thought was actually inappropriate to come out, but I want to save it for redirect. So let's have a discussion and see what the jury thinks, because Maria says she's still confused as well. But let's see what they get in front of the jury about, does this look shady, what Brian Albert and maybe Brian Higgins did with their phones?
All right. Next question.
Thank you, Your Honor. Isn't it true that you were, in fact, ordered to preserve your cell phone by the Commonwealth?
At some point, I was made aware of that, yes.
All right, let's just get to the brass tacks. Where's your phone?
My phone was upgraded and traded in for a new phone.
Your phone was upgraded and traded in for a new phone?
Yes.
Okay. Another way to say that is you traded your phone in and got rid of it, correct?
I traded my phone and upgraded it. Yes.
When did you get rid of your phone ending in 0888?
I upgraded my phone in September, third week of September, maybe around 22nd.
The 22nd of September?
I believe so. I can't be sure the exact date.
So according to you, you got rid of the phone that was the subject of a court order preservation the day before it was ordered preserved, right?
Rephrase the question, please.
This order was just stipulated. This order is dated September 23rd, 2022. It was just stipulated that on the 23rd or 24th, you were then sent a notice to preserve the phone. And your testimony is on the 22nd, the day before this all happened, you upgraded your phone and got rid of it in total, correct?
I upgraded my phone on and around the 22nd, yes.
And you knew that all of the data on that phone would be factory reset and destroyed.
Yes.
Do you know that, sir?
I do not know that.
How many times?
I don't know that that's true, number one, but I'm not going to dig into it too much because I want to save some of that for redirect, because I think the Commonwealth actually handled it pretty well. Leah M said, Peter, how mad is the Commonwealth about this phone, if at all? I don't know that they're mad for a couple reasons. Number one, let's wait till redirect to see if we're really missing that much from the phone. And number two, I mean, if he got rid of bad evidence, listen, the prosecutor's supposed to fight for truth and justice. And so that's what they should want to do, not just get convictions. But my guess is if he got rid of the phone and it may have had bad stuff for the Commonwealth on it, That's probably why he would have gotten rid of it, right? I'm not saying there is, but I don't think it hurt the Commonwealth's case that he doesn't have his phone. I'll just put it that way. Lori said, your channel has made me realize how important it is to learn about the people running for prosecutors or judges. I appreciate your fairness and truth. Lori, thank you, because this is so important. I'm so glad that's something you're learning. I try to do, I mean, we talk so much about cases and likes and subscribes and whatever, the YouTube-y stuff, but in reality, lives are affected so much more by your local judges and prosecutors than the president. Honestly, I'm not saying the president's not important, but people's everyday lives can really be impacted by things that they don't care to vote on because they don't realize how important it is. So thank you for highlighting that, Lori. Daybreak said, could defense call a law enforcement from another jurisdiction as an expert regarding what should be considered conflict of interest? They can call them for all sorts of things. So yes, from this jurisdiction or others, about what's proper police work, what's proper protocol, what's proper conflict of interest, crime scene, investigation and preservation, all sorts of things that I think could be happening. A little bit more from this exchange.
Times have you upgraded your phone to your iPhone?
I'm not sure. 4 or 5 times, maybe.
You're aware that when you turn a phone in and you upgrade it, the phone that you turn in, that data is factory reset, meaning it's gone. It's destroyed off of that device, correct?
Well, I think some data transfers and some doesn't.
I'm not talking about a backup. I'm talking about the physical.
So yes, he is right. The physical phone gets factory reset, yes, but it doesn't mean all the data goes away necessarily.
Physical phone. That physical phone becomes a brick when you turn it in, correct?
Correct that it becomes a brick? I don't know.
It becomes effectively a brick. There's no data left on the phone. I'm not talking about backup data onto a cloud. I'm talking about that phone.
So the old phone, yes.
Yeah, it's just everything on it's destroyed, correct?
Right, although some of the data transfers to your new phone.
And you're aware that the very data that you were ordered to preserve would have been destroyed, according to you, the day before. Correct?
Rephrase your question or ask me a question.
Are you claiming that you got rid of your phone?
Did you see how he said, rephrase the question or ask me a question? I think that was a little indication like you just made a statement. There was no question there. Or was there a question, sir? Again, experienced witness, law enforcement, doesn't surprise me.
On the 27th?
I upgraded my phone around that. I'm not sure if that's the exact date, but yes.
So it could have been after the 27th?
I don't think it was after the 22nd.
Could have been the 24th?
No.
Could have been the 25th?
No.
So you're absolutely sure that you could not have upgraded your phone and gotten rid of it anytime after the 23rd when this judge ordered that it be preserved?
Because that would be a problem, right? And by the way, I want to highlight what the defense is saying here. They're saying he destroyed it before anybody even told him to preserve it. And then the court ordered him to preserve it. Never does the defense say that it was ordered to be turned over to the defense. And that becomes important later where I think something inappropriate comes out that the judge allows. Shane said, I just can't believe the crazy dog who was barking at people earlier in the night didn't react when the front of the house was lit up like a Christmas tree and vehicles and people screaming. I just don't buy it. I agree. I tend to think common sense would say the dog would, make some noise about that. But I'll also say nobody outside said they heard a dog barking inside, right? I haven't heard that testimony yet. So I don't know. I don't know what to think.
No.
Because you know that if you got rid of that phone after you had been notified that you were ordered by a court to preserve it, you'd be committing a felony.
Objection, Your Honor.
Then you could be in trouble, right? So somebody asked if you got in trouble. If you do it before the technical court order, definitely better timing.
Sustained.
So you now claim that you got rid of the phone on September 22nd, 2022, hours before you were ordered to preserve it. That's your testimony, correct?
Yes.
Is that just a coincidence?
September 4th was my birthday. The phone was broken and failing. I had planned on getting a new phone, and that just happened to be the day that I got it.
Happy birthday. Was that a coincidence?
Objection.
Sustained.
A lot of coincidences, and a lot of you are bringing them out too. KRH, I get that, but you can't use it as a sword and a shield, right? You can't use it when you want to say I'm drunk, but then not say I'm drunk because then it could affect your memory, or the jury may think you shouldn't have been driving.
You were asked at another hearing in June of 2023 that exact question, correct? Whether it was a coincidence. Do you remember that?
I don't.
You recall being asked, quote, so it's just a coincidence that within minutes, hours, or
Objection,
days,
Your Honor.
Let's hear the question first.
within minutes, hours, or days of you trading in your phone, that phone you had in January of 2022, that you were ordered to preserve it? Answer, yes. Question, that's a coincidence? Answer, yes.
Objection. We'll strike.
I'll let that stand.
That was your testimony.
To let it stand that was his testimony. But not only he, got rid of his phone, but it sounds like from the questions, now technically this didn't come into evidence because I didn't hear him confirm it, but it sounds like Brian Higgins did the same, which is wild when we get to the actual night eventually. So much to get through today.
Conversations about the phones. I just can't say if he said he was going to get rid of his phone or not. End quote.
Right.
Does that help refresh your recollection?
Yes.
So now as you sit here and you answer my question, did you and Brian Higgins have a conversation about your phones?
I don't remember having that conversation with Brian Higgins.
All right, let's shift gears. Before I shift gears,
He's like, let's shift gears. Actually, let's talk a little bit more about the phone. And again, some of this drags on a little long and cross, I thought.
you're aware that Brian Higgins has also gotten rid of his phone, correct?
I am not aware of that until after the time you're talking about.
That sounded like he was going to say something that wasn't true and then corrected it mid-sentence. I am not aware of that. Am is present tense. I am not aware of that at the time that it happened or whatever. It's like, it sounds like you are aware of it now.
Without qualifying your answer my question. As you sit here, you're aware that Brian Higgins has also gotten rid of his phone.
I know at some point Brian
Yes or no, Mr. Howard?
did he?
Objection, Your Honor.
Can you answer that, yes or no, sir?
Yes.
Now I'd like to shift gears and talk a little bit about Michael Proctor. Did Michael Proctor come into your home at 34 Fairview on January 29th?
Yes.
Michael Proctor? Let me rephrase the question. I want to make sure we're
That's a
hours of a criminal investigation TV show called First 48.
Objection, Your Honor.
system.
Do you think the first 48 hours of a criminal investigation are critical?
Objection.
You do know that the
He
law
tries to ask that question 10 different ways. And I think maybe he knew. I was like, why does he keep doing this? Like, obviously they are. Obviously the first 48 hours are important. But I think the defense knew what Brian Albert was going to say, which I think they do get him to say it eventually. Is that like he doesn't know after all this background and all this great cop and investigating and featured on a TV show, et cetera, and he's going to say he doesn't know if the first 48 hours are important.
longer you wait to properly investigate anything, the better chance that evidence can be manipulated or destroyed, right? You agree with that?
Yes.
Did an investigator or any forensics team ever come into your house, ever, to photograph your entire home?
No, I wish they had.
Did an investigator, yeah, me too.
Objection, Your Honor.
Did an investigator or forensics team
He wishes they had. He wishes Karen Reed and John O'Keefe would have gone into the house and the defense, or he wishes the investigators would have gone to his house. Sorry, not Karen Reed and John O'Keefe. He says that later. He wishes investigators would have come into his house and the lawyer says, yeah, me too. Yeah, me too. A little snark there, which again can go kind of either way. Then he gets into hand-to-hand combat training in the military, police academy, defense training, trained in boxing. They talked about him fooling around, fighting stances at the bar. And then we get to another very weird exchange that a lot of people are asking questions about that we're going to bring him out now, about where was his phone and what happened on the night John O'Keefe died. Before we get to that, Azam said she wanted to sneak in. She's with her students. 350K by the end of the week. Could be by the end of the day, right? We're really close to 350,000 subscribers. If you guys all subscribe watching this, we'll easily hit it by the end of this video. So go ahead and hit that subscribe button and make sure you like this video as well. So what happened with his phone and that night?
so you instead of just on the charger of the next day?
That's just what I've always done. I just keep it in my bed. My wife does the same thing. So
Neither of them charge their phone overnight. They leave it on their bed for the most part, which again makes sense if you have kids. So we'll listen to this exchange, and then some things don't make sense.
So now you've got two phones in the bed.
Yes.
Okay. And your glasses.
Yes.
Right between the two of you.
Yes,
Got it. Your phone have a ringer on it?
it does.
Ever thought about maybe turning the ringer on just in case the kids need to get a hold of you?
Sometimes it's on vibrate. Sometimes it's on ring. It depends.
Yeah. Depends on you. Just put it on ringer. Wouldn't that make more sense to go to bed, put it on ringer?
Objection.
Can you answer that?
All I can answer is that I sleep with my phone in my bed. That's just what I do.
Well, he gave a reason because if his kids call and whatever, it's like, well, then why don't you turn the ringer on? Why don't you turn the ringer on? Why just put it in your bed? That's not going to get the job done.
And you know what I'm about to ask you. This is why you're saying you sleep with the phone in the bed, correct?
All right,
I
so that's sustained. That's stricken. Just one, Mr. Jackson.
All right.
She's like, come on, Mr. Jackson. He's like, you're saying you sleep with the phone in the bed, which makes absolutely no sense to sleep with the phone in your bed and let it die overnight and not charge it and not have the ringer on. You act like you're waiting for a call from your kids, but if you really were, you would have the ringer on. It could die, and that would make it even harder for your kids to get a hold of you. But you have to say you slept with your phone in your bed, right? Because you know what I'm going to ask you next. That can be stricken. That's not an evidence, but guess who heard it? The jury and all of us. So now I'm like, oh, what is he going to ask next? Because I don't know what he's going to ask next. A lot of you might.
What else is in the bed with you? Your keys, your wallet, any other pocket items?
No.
Just the phone and your glasses.
Yes.
And Nicole's phone.
Yes.
Right between
That's a little snark there too.
the two of you.
Usually, yes.
What about that night?
Yes.
Sir, did you make any phone calls after you went to bed between the hours of 1:45 a.m. and 6:30 a.m.?
Yes.
Who did you call?
I inadvertently called Brian Higgins.
Say what? In the middle of the night, you called Brian Higgins? It was inadvertent because the phone was in his bed with him. So he rolled over on it, butt dialed it. We'll get a little more details probably than we want later. But that's what the defense lawyers are saying. That's why he had to say he's sleeping with the phone in his bed.
What time?
I don't recall the exact time. After 2.
2:22 and 35 seconds. Does that sound familiar?
Yes.
Did you speak to Brian Higgins at any point between 1:45 a.m. and 6:30 a.m. that night?
No.
You say you inadvertently called him at 2:22 in the morning.
Yes.
How did you inadvertently call him?
Well, I don't know because it was inadvertent.
So I have to explain that.
Well, it's kind of like a butt dial.
I don't like about that. All right. How long have you used an iPhone?
A long time.
As a matter of fact, you've been asked this question before, haven't you?
Yes.
Hence my question. You knew what I was going to ask you.
Objection, Your Honor.
I'll withdraw.
Withdrawn.
You indicated previously at a different hearing in June of 2023 that you were, quote, hanging out with your wife, and you must have butt dialed Mr. Higgins, correct?
Yes.
At 2:22 and 35 seconds on January 29th, 2022, correct?
Yes.
Just so happens to be right in the timeline the defense say stuff's happening, right? And I think this is going to correspond very interestingly to that old Google search that I think is perhaps the best evidence for the defense. How long for a body to die in the snow? Shane, I agree with you. Just common sense tells you what? Common sense makes you scratch your head that he couldn't say yes to that. He doesn't know why they didn't. It wasn't his investigation. It was theirs. But by saying no, it makes me go,
You were asked how that could have happened, much like I just asked how that could have happened, right?
Yes.
And in that hearing, you said, quote, I'm not totally sure. Similar to what you just said here.
Yes.
And here you added that it could have been a butt dial.
Yes.
You were then called back to that same hearing, but at a different date, an ongoing hearing, right?
Yes.
That was in July of 2023, correct?
Yes.
You then changed your testimony and said, and I don't mean to be indelicate, your testimony was then that you were in an intimate situation, I'll put it that way, with Nicole at the time. And that's how you butt dialed Brian Higgins, correct?
I don't believe I said that's how I butt dialed Brian Higgins.
That's the time.
I think I said there was a time frame that was close.
Okay.
So I didn't say that, no.
What you said was,
so basically, he's fooling around with his wife, accidentally hits the phone, calls Higgins. Higgins calls back. Somehow he answers it. Now, this is another thing, and Shannon, I think that's a great point. Obviously, you sleeping with the phone in your bed's not working. I think that was the point he was making with why not just keep the ringer on, or it could die if it's not charged. But what I will say is another thing, unpopular opinion. I don't think the defense attorney is right that the only way you can answer your phone call is by swiping. There are multiple ways you can answer your phone, whether it's on, off, lock screen, if you have headphones in, Bluetooth in the car. There's lots of different ways you can answer your phone. So I think that may have been a little bit of a miss. And again, I think he pushed for a little while into that. But oh boy, is that coincidental once again that he calls who? The guy the defense thinks is involved, Brian Higgins, the guy they think is interested in Karen Reed, the guy that may or may not have gone to the police station at 1:30 in the morning, 30, 45 minutes before you call him, and then he calls you back and you have a couple second phone call. Now, some people say a couple seconds is not enough for anything to really happen. And that might be an argument the Commonwealth has to make, again, trying to refute the arguments the defense is making, which isn't good when you're the one with the burden to prove the case. But he goes through again and again. He was not aware of that call. He did not answer that call. Some of what Albert said was kind of confusing as well. Judge eventually tells him to move on. Jackson, they don't parse words, these defense attorneys. They say it. They say, you say it's a butt dial to cover it up, right? They don't just leave things to the jury's imagination. They take that last step. They let the witness deny it because they don't care about the answer. They care about the jury hearing the question. So then, for somebody they don't really know that well, John O'Keefe, and for a situation where they didn't go outside to see what was going on, they didn't want to be nosy, for something that they're really trying to distance themselves from now, that morning they were awoken. They made quite a few calls and got very involved in this case. Let's take a listen.
Make a call. Is that right?
No.
Isn't it true that you grabbed your phone and called? They call at 7:20 in the morning?
Yes, but that's not when I was awoken by my sister-in-law.
Sorry, that was my question. After you were awake and you're up, you
Right.
started making calls.
Right.
My question is, what was the first call you made at 7:20?
Can I look at this?
If that refreshes your recollection with the court's permission?
Yes.
5 kids, right?
Yes.
You have in-laws, cousins, huge family. With the court's permission?
Yes.
At 7:20, I called Brian Higgins.
Mr. Albert, you have 6 siblings and 5 kids, right?
Yes.
You have in-laws, cousins, huge family, correct?
Yes.
But on the morning you find out that John O'Keefe is laying dead or dying on your lawn, the first call you made at 7:20 was to Brian Higgins. Is that right?
Yes.
Why? This guy's not your best friend. He's barely a guy, right? He was there. He was around that night. Fine. So what? If he really left and didn't see anything, didn't know what was going on, why would that be your first call? You had a bunch of family members at the house the same night that had the same connection, if not more of a connection to John O'Keefe. Why wouldn't you call them first? Why is Brian Higgins the first one you called? That to me was really like, wow, how does this all fit together? This is legitimately a murder mystery. Legitimately. But that's not the only person he called. Again, it's 7-something in the morning, an hour after he's woken up out of a stupor and cops are showing up to ask him questions. He's calling all these people.
The same person you had a call with, or at least the logs indicate you had a call with at 2:22 in the morning, correct?
Yes.
During that 7:20 a.m. call, did you two discuss the 2:22 a.m. calls?
No.
I thought you just said that you told him, oh, I think I made a butt dial.
Yeah, that was later in the morning when he came to the house.
Not on that 7:20 a.m. call.
No.
What did you talk about on that 7:20 a.m. call?
I informed him of what was going on at my house. We were out the night before, and I thought it was important for him to know what had happened.
Why?
Robert, I have a couple more questions about the phones or the phone usage that morning and the day throughout the day. You called Brian Higgins at 7:20 a.m. for 1 minute and 56 seconds, correct?
Yes.
Brian Higgins called you at 7:30 for 5 minutes and 47 seconds.
Yes.
You called Brian Higgins
So this is all before he called anybody else. They've called each other like 3 times.
at 7:57 a.m. Spoke for 12 minutes and 33 seconds.
Yes.
You then called your brother, Kevin Albert, at 9:40 a.m.
So I think that's 3 calls with Brian Higgins before he calls his brother, also a cop, Kevin Albert.
Spoke for 1 minute and 5 seconds.
Yes.
Chief Berkowitz called you at 9:50 a.m. and left a voicemail. Is that right?
He didn't leave me a voicemail, but I think he called me.
You called Chief Berkowitz back at 9:54, 4 minutes later, and spoke for
That's Kenny. That's Kenny, buddy of the Alberts, right? Shy Gal. I mean, you're just speaking common sense. And usually a jury's going to start there. Rick, I don't think, there's definitely evidence around it, right? Her car has damage to it. He's on the ground where people said they were going. She was driving her car. And at least some first responders that are supposed to be independent witnesses say, she said, I hit him. So there's definitely some evidence, but it seems like it's like a speck of evidence compared to all this other stuff going on, which again, usually plays in favor of the defense.
4 minutes and 40 seconds, right?
Yes.
You called Jim McCabe at 11:30 a.m. Is that right?
Yes.
Jim McCabe called you back at 12:20 p.m. You spoke for 7 minutes and 52 seconds.
Yes.
You called Kevin Albert again at 2:01 in the afternoon and spoke for 8 minutes.
Yes.
You called Kevin Albert at 6:45. I'm sorry. You called Brian Higgins at 3:24 p.m. and spoke for 6 minutes and 5 seconds. Is that right? And if it refreshes your recollection, there's a second page.
Once you told him what happened, if it's just some guy that was at your house, once you told him what happened one time, why didn't you talk to him 5 times? These are all calls made right after.
Second log. You'll turn your attention to the 3:24 p.m. time frame.
Trying to find it.
Take your time. 3:24 p.m.
I see it. Yes.
And there's a second call. You call Brian Higgins at 6:12 p.m. to speak for a minute and 7 seconds, right?
Yes.
And then the third one on that page, you called Brian Higgins at 6:35 p.m. spoke for 10 minutes and 12 seconds, correct?
Yes.
Turning back to your call logs, you called Kevin Albert at 6:45 on the next on that same day. Spoke for about 16 minutes.
A lot of calls.
Yes.
A lot of time.
Then on the next day, January 30th,
For somebody that has nothing to do with this case, I'm not a party. I'm not a victim. I'm not a defendant. I'm not even a witness, right? Like, they didn't even talk to half the people that were there, right? We're going to find out Colin and Caitlin, they didn't even talk to him for 18 months. And he's calling all these people and getting everything together. There were people in that house that weren't even interviewed by law enforcement for 18 months. So why is he so intricately and intimately involved in all of this right after? I get telling people what happened. If you were there and somebody showed up dead on the lawn, if I was at somebody's house, I'd be like, holy crap, that's so sad. Is there anything we can do? Can we, send flowers to the funeral, whatever? And that's it. I wouldn't need to continue to have conversations about it over and over again if I really never saw the guy and I've never really met the guy. And it happened after I left.
you called Chief Berkowitz and spoke for a minute and 6 seconds.
Yes.
And the following day, you spoke with Jim McCabe, who called you at 8:04 p.m., correct?
Yes.
And finally, Chief Berkowitz called you at 1:48 p.m. on February 1st, right?
Yes.
3 days later, you spoke again to Brian Higgins at 8:48 a.m. Is that right?
Yes.
The subject of these calls, Mr. Albert, were all about the fact that John O'Keefe was found dying on your yard, on your lawn, on January 29th, 2022. Isn't that right?
I don't know the subject of all these calls. No.
You had to have been talking about that event.
Of course, it was a horrible situation that was going on. Everybody was distraught, and there were a lot of phone calls. This call log doesn't encompass all the phone calls.
No, it doesn't.
There were a lot of phone calls being made to a lot of people because of this horrible situation.
And the point is, Mr. Albert, those many calls that you just described, especially as they pertain to Brian Higgins, Jim McCabe, Kenny Berkowitz, your brother Kevin Albert, were those many calls an effort to get stories straight at the time?
No, absolutely not.
Were those many calls an effort going into that?
So no, my other question is, why didn't we hear about Chris Albert, Colin Albert trying to hide it, try to cover them up? If he was really trying to cover that up from the jump, why didn't we hear any of that? So that's kind of a hole in the defense's argument that I would have brought out if I was the prosecutor. If I would have been like, well, did you call Colin Albert? Oh, you didn't want to cover anything up with him? Maybe the judge wouldn't allow that sarcastic questioning, but I think that's kind of interesting. Mary Claire, I think that there's like a line, but I'm not positive how open the gallery is. Jojo, have you heard a prosecutor dropping charges mid-trial? Does this happen? Yes, it's actually happened to me. When I was defending a case, one time they did drop the charges in the middle of the case when they realized there was just kind of nothing there. But sometimes it takes that long to convince them. I don't see that happening here. Aaliyah, Peter, what, if any, experience do you have with Cellbrite? A little bit. Different. So I've seen also some different stuff used and different programs used. If it says call answered, is it actually answered? Yes, but it doesn't necessarily mean the person talked to them, right? It's kind of like I signed my name that says I read the bottom, but I didn't actually read it. You don't always have to swipe. Sometimes you can hit it, especially if this, my dad, it happens to my dad all the time. He butt dials all the time and he'll pick up and not know that he picked up all the time. A lot of times he doesn't lock his phone. So if it does leave it open, it's a lot easier to hit something to where it does answer the call and you might not know, even if somebody's screaming on the other line. Okay. So that was basically it for cross, but I do want to listen to some of redirect because I thought there were some good points made by the Commonwealth. So let's listen here.
Prior to any notification you received from the district attorney's office or anything in relation to preserving the phone, is that correct?
Yes.
Now, with respect to that, as far as the information contained within the phone,
And then eventually you'll hit some train tracks.
with respect to your phone, that was something that you had upgraded prior to any notification you received from the district attorney's office or anything in relation to preserving the phone, is that correct?
Yes.
Now, with respect to that, as far as the information contained within the phone, there are certain types of information, are you familiar with being sort of backed up by the cloud?
Yes.
Would that include calls?
It could.
Could that also include text?
Yes.
Could that include photos?
Yes.
Could that include contacts?
Yes.
And the information that you were shown as far as certain call logs or call records, as far as you know, was that generated after that September 2022 date?
Yes.
Now,
So that's a good point. Number one, they confirm none of this happened after the court order. I get that people can roll their eyes at it, but technically it didn't. Number one. Number two, we still got all that data, all those calls, what was picked up, what was answered, what was sent out. Still somehow we were able to get all that from what was stored in the cloud, right? And I thought that's a good point for the Commonwealth, that the evidence is still there, right? There's still some evidence to be gotten. The defense wants to throw all this stuff up against the wall and act like there would have been evidence there, but they don't know that. And there was evidence that was gotten from this phone. I think that's a good point made by the Commonwealth at this point. Laura said, could they look and see how often he butt dialed before that night, or can they only view a certain time frame of cell data? So the hard part about knowing if something's a butt dial or not is the person's probably got to tell you, right? Because it doesn't look different on a report. Brooklyn Basement. If the trial ended today, where do you stand, Peter? Easy, not guilty for me. But it should always be a not guilty until the state presents all their evidence, because I cloak the defendant in a presumption of innocence in every case. So no surprise that it's not guilty for me at this point. All right. So we usually try to keep these videos to about an hour, maybe an hour and 15 minutes, but there's no Daybell video today. It was kind of a slow, boring day in court there. Not a ton to break down. So we're going to go overtime here for probably another 15 minutes. So stick around, hit the like button for overtime, because there was so much that happened today. I don't want you guys to miss anything.
With respect to the preservation, that was in regard to a motion the council had filed for your physical phone, correct?
Yes.
Are you also aware of a judge's order denying that repeatedly as far as them gaining access to your physical phone?
Objection.
I'll allow it.
Yes, it was denied on multiple occasions.
I'll strike.
So not all texts, not all texts. You can still get some texts too. I don't know what they did get or didn't get, but it's not impossible to get information always. Sorry, I even missed what was just said there because I was reading comments.
Now, with respect to the preservation, that was in regard to a motion the council had filed for your physical phone, correct?
Yes.
Are you also aware of a judge's order denying that repeatedly as far as them gaining access to your physical phone?
Objection.
I'll allow it.
Yes, it was denied on multiple occasions.
So a couple things there. So what just happened in that exchange was, well, the defense filed a motion to get your phone and the judge denied it. And the prosecutor said repeatedly. So if you want to get on Brian Albert, which I did the first time listening to it, saying, oh, he said that she denied it repeatedly. It's like, okay, he just wants to like make it sound even worse. And then the defense objects. The judge says, I'll allow it. And he says, yes, the judge denied it repeatedly. Then she says, well, I'll strike the repeatedly part. It's like, well, you didn't strike it when the Commonwealth asked repeatedly, but you did with them. And number one, this is what I was talking about before. This was totally inappropriate, in my opinion, for this to come out. Because never, ever did the defense say, we asked for it and you didn't give it to us, like they did with the dog stuff. But they didn't do it with the cell phone. So to let the prosecutor get into the fact that the judge denied a motion of the defense is totally inappropriate. This was all about the court order and the state or Commonwealth asking for it to be preserved. And that all did happen. So I had a problem with the judge letting them get into this and then to try to say like, oh yeah, I'll strike it for the repeatedly part. I didn't love that. I didn't love that. And then we get to, again, some of the parts where I think, witnesses and prosecutors can go a little too far. But we're going to listen to them again say they never came into the house, but we wish they would have.
If you recall, what, if anything, in general terms, you were discussing with either those people in the logs or other people in general?
In general, I'm sure there was some discussion about the awful thing that had taken place, and there may have been other calls unrelated as well.
Can I have one moment?
Yes.
Early morning of January 29th, 2022, did John O'Keefe ever come into your house that night?
John never came into my house that night. He would have been welcomed, and the defendant would have been welcomed with open arms had they come in, and I wish they had. I really do.
Not just John O'Keefe, but the defendant would have been welcomed with open arms, and he wished they would have. Too far, in my opinion. Melanie said, so 2 weeks in and still no evidence against. I wouldn't say no evidence, but definitely not enough to prove this case beyond a reasonable doubt. Definitely not enough at this point. Okay, I'm going to jump now to recross, which he said will be quick. So let's listen to some more kind of impeachment or trying to make it look shady that he was talking to Lally when maybe he shouldn't have when they were on break.
District Attorney's office, which is in Canton.
This morning when I asked you, you said you couldn't quite remember where it took place.
You're right. I couldn't remember this morning.
And I asked you, there'd been the DA's office, and now your memory is refreshed?
Yes.
What refreshed your memory between this morning and now?
I was just thinking about it in my head and reminded myself that it was the DA's office. You caught me off guard when you would ask me. I didn't have it at the top of mind.
Did you talk to Mr. Lally over the lunch hour?
Briefly.
Bring up the fact that that's cell reception in your house over the lunch hour?
Did you catch that? Did you talk to Lally over the lunch hour? This is again where I thought maybe he was not going to start with the truth. He was like, yes.
You caught me off guard when you would ask me. I didn't have it at the top of mind.
Did you talk to Mr. Lally over the lunch hour?
Briefly.
Bring up the fact
Briefly, it's like that's a yes.
Did that cell reception in your house over the lunch hour?
Just now, no.
What did you talk about at the lunch hour?
Just what was how much time I was going to have left on the stand. That was really about it.
So you and Mr. Riley talked about the fact that you've been on cross-examination for 2.5 hours, and the conversation consisted of probably about 10 minutes.
Yeah, I think he was going to lunch or doing something. So
You didn't talk about the substance of your testimony.
no.
You didn't tell you what questions he was going to ask you on redirect.
Maybe mentioned one thing he may ask me, but that was it.
What was that?
Just he was going to ask about what happened at the house in the morning. That's some of the questions on redirect. That's all.
Meaning he was going to ask you the question about whether or not John came in the house?
No, not necessarily.
Just
Just
ask you about whether or not you had that cell reception in the house?
no.
What was he going to ask you?
He was going to ask about the morning of the incident, about coming downstairs and why I didn't go outside.
Did he tell you what he thought would be helpful for the Commonwealth?
Nope.
Did he tell you how he thought you should answer that question?
No.
He did ask you about a situation concerning motion to preserve, correct?
No.
I'm sorry. He asked you on redirect about the motion.
Oh, yes. Yes.
And he mentioned that there was a motion that had been denied for us to get for the defense to get access to your physical phone, correct?
Yes.
You're aware that that motion was denied in October of 2022, correct?
Yes.
You'd already gotten rid of your phone a month earlier, hadn't you?
Yes.
And the preservation order from the judge was still in place when you got rid of that phone, wasn't it?
No, I believe the phone was upgraded prior to the preservation order.
Oh, right. The day before.
Yes.
Sorry.
All right, Mr. Albert, you.
All right. So that is the end of Brian Albert. We are going to hit the other witnesses from today. Alan said, witness talking to the prosecution over lunch hour is sus. Happens all the time. And I really think sometimes you guys, the chat, sometimes you guys are like, oh, no, that's fine. Sometimes lawyers prep their witnesses. And then some cases you're like, that's horrible. I always think it's horrible. I think you shouldn't. I think you're not supposed to. I think certain judges would really hammer you for that. Bone Arrow said, hey, Peter, if something is stricken from the record, is that grounds for appeal? Yes. If the judge grants a objection improperly and strikes something that should have come in and was material and reversible error, it could. I mean, the jury just heard all that and you can't put that crap back in and all that. Yes, I agree. Mary Claire, 10,000 watching, 2,500 likes. Let's get this video to 10,000 likes. Hit that like button if you guys have not hit it already. Then we get Brian Albert Jr. And I'm sorry, I kind of just want to watch him walk in because he is massive. I mean, I knew these were big dudes, but this guy is massive. I don't know that it matters at all, but I was taken aback when I saw him walk to the stand next to this cop. I mean, like the guy doesn't, the bailiff doesn't even come up to his shoulder, literally. The dude looks like a giant. So anyway, totally similar story. Parents got home at 12:10, 12:05. But the big part that I didn't know, I wasn't expecting, I didn't know he was going to testify to this, is he saw a dark SUV that matches the description of Karen Reed's vehicle that he didn't recognize at his house.
That area of the dining room table, how is it that you were able to see out in front of the house?
There's two windows there. So I just turned around and looked through the blinds.
And when you looked through the lines, what is it that you saw out in front of your house at that time?
Yeah, so I saw a truck, which was Julie Nagel's brother's truck, I believe. And that was a little ways, almost like in front of the driveway of the house. And then a little ways in front of it, there was another car that I hadn't recognized before. It was a dark SUV-ish. That's all I knew about it and could see about it.
Now, similar to yourself,
So this puts Karen Reed's vehicle at their house between, 12:15, 12:30, and 1:30 a.m. It's interesting because they don't see or hit anybody, hear a screech, hear yelling, hear grass clacking, a glass breaking or light shattering, or see a body in the yard, things like that. Vicky said, how many people in the chat would not go out and talk to EMT police if a body was found on their lawn? I mean, I 100% would. And I'd be looking out the window. I'd be captivated by it. I'd be like, what the heck happened? Especially if I knew the guy, I'd be like, oh my gosh. And my calls would be to his family. Is nobody calling John O'Keefe's family?
with anyone else from sort of the group of people, either in the kitchen or in the house, did you observe near a window or a door that was looking out?
I believe my uncle Matt McCabe noticed the car outside as well.
And with respect to the dark SUV that you didn't recognize and what you thought was Julie Nagel's brother Ryan's truck, was there anything in between?
100%, Shane. And it's interesting because sometimes it's like they would never know because Lally's not going to take the stand. So he was probably thinking, is this something I could lie about? You know, I mean, it's not just him. A lot of witnesses struggle with those kinds of questions.
Truck and the dark SUV that you saw outside?
Not to my knowledge, I didn't see anything, no.
And as far as the weather, when you looked outside, what, if anything, did you know about the weather?
It was definitely snowing. I wouldn't know how many inches, but I would say an inch or two of snow at that point.
Definitely snowing, guys. It's definitely snowing. I wanted to leave that in there because you might not know it's snowing.
Now, with regard to being out in front of your house, those two vehicles, do you recall which direction they were facing?
Yeah, they were both facing, going up Fairview towards Cedar Crest. So whatever this is, I don't know.
But let me ask you probably in a better way. As far as what was facing towards your house, was that the driver's side or the passenger side?
Oh, that would have been the passenger side.
And that's with respect to both vehicles, is that correct?
Yes.
Now, at any point in time during the time that these vehicles were up in front of your house, do you recall hearing anything or any sort of noises coming from the front of your house through your attention?
No, I didn't hear anything. No.
And as far as looking out the window and seeing these vehicles in front of your house, how many times did you look up?
I believe I looked at that one time, and then I think I looked at one more time after that.
And as far as your friend Julie, if you know about how long was she out in front of your house at that time?
I would say not more than 5 minutes, more likely about 3 or 4 minutes she was outside.
And when did you see her outside in relation to the truck as well?
Yeah, I saw her at the passenger door of the truck.
Now, that vehicle that you observed that you didn't recognize, the darker black SUV, was that vehicle in one place or more than one place during the time that you looked out the window and saw?
Yeah, so the first time I looked, I would say it was closer towards the mailbox, maybe a little bit in front of the mailbox. And then the last time I looked out the window, it had moved further down, closer to, I'll say, the flagpole. So closer that way, it went down that way, towards the flagpole.
So closer to there's an area in the front of your yard where there's flagpoles, is that right?
Yes.
Now, as far as when it moved, as far as the weather and the snow was concerned, could you see anything in relation to the roadway behind the SUV as it once it had moved from that initial position to the following position by the flagpole?
Yeah, I had noticed just some tracks in the snow, indicating that the car had moved up.
Now, your friend Julie, did she take that ride home?
All right. So he also saw that the car moved. He went to bed, give or take 2 a.m. John O'Keefe and Karen Reed never came inside the house. On cross, the first time law enforcement ever spoke to him was 18 months after the incident, which I just found appalling. And it's just, that just makes no sense to me. But the defense does get into the fact that, oh, you saw this car, but you never saw a 220-pound man laying in the front yard.
Towards the driveway along this way, going up towards the flagpole?
And you view those tracks kind of leading up towards the flagpole, correct?
Yes.
So you'd agree that the visibility and lighting in front of the house was good enough that you were able to see tire tracks in the snow, correct?
Sure.
But you did not see a 220-pound man lying in the snow in your front yard.
Objection.
Is that something that you saw, sir?
No, I didn't see that.
Who was in the house the second time that you looked out the window?
It would have been my mom, my dad, Brian Higgins, my sister, Julie, Sarah, Uncle Matt.
Mr. Albert, you testified on May 8th.
So they all would have been there when Karen Reed hit John O'Keefe and would have left when John O'Keefe was laying in the yard.
In 2023
Mhm.
in another grand jury.
Mhm.
And you said, quote, I'm not sure if Brian Higgins was still there. I know he left at some point. Do you recall that testimony?
I mean, I know he left my house at some point. I just don't know exactly when it was.
You were asked specifically at the time that you looked out the window, who was there? And you said, I'm not sure if Brian Higgins was there.
Yeah.
Isn't that correct?
Okay, if I said that, yes, because I was not sure. I'm still not sure that if he was there or not.
So you're not sure whether Brian Higgins was there when you look out the window, correct?
No, I'm not sure.
Jump ahead a little.
So, Mr. Lally, what page or something?
Is your recollection refreshed?
Sure, yeah.
Why didn't you look out the window that morning?
Well, I say here that I just would give me anxiety to look out the window.
Is there a reason that you didn't want to look outside?
I'm just an anxious person, and I got overwhelmed. I think most people would be overwhelmed in that situation.
Did you say that this was kind of a new thing for you, for cops and police to be at the house?
Yeah, that's never happened before. I've never had cops at or near my house.
And it made you overwhelmed, correct?
Yeah, I get overwhelmed easy, so.
Mr. Albert, how many times did you discuss this case with members of your family before you spoke to the Massachusetts State Police on May 18, 2023?
I don't have an answer for that. I don't know how many times.
Hundreds?
We talk about it pretty decent. I mean, considering,
What members of your family have you discussed this with?
my parents, my sister, occasionally my aunt, JJ, and Uncle Matt.
Would you say it's been hundreds of conversations?
Well, I guess you can, you'd have to split it up and quantify what conversations were about the actual case and what conversations have been the harassment we've faced since then.
So I think that's the first time, unless I missed, that one of the Alberts mentioned that they have been harassed in reaction or as part of this case, which I found interesting. I said it in front of the jury. So the jury has heard that they're harassed. I can cut both ways. Maybe the public thinks Karen Reed's innocent, or maybe the public is all wrong and being so horrible to the Alberts and the jury's going to feel bad for them. What do you think the indication is from him saying that?
And all of these discussions took place with you and members of your family prior to your interview with the Massachusetts State Police, correct?
And no, we've talked since then.
You need to speak with them about this case
Not,
since your interview.
I don't know what you mean by this case. This case meaning the actual case at hand, or just the case about the harassment we faced?
I'm talking about what happened on January 28th and January 29th.
but there's really nothing to talk about those specifics. No, because we have nothing to say about that. We weren't part of it.
Mr. Albert, you looked out the window multiple times on January 29th, correct?
You had nothing to say. You weren't part of it. And I get that, except that your dad was calling everybody and going over to people's houses that were going to get interviewed. And he was definitely feeling like he was part of it.
Twice, I think I said.
You never heard any sort of commotion outside?
No,
You never heard screaming, yelling, or the screech of brakes in the front yard?
no,
You never saw a 220-pound man in dark clothes in the white snow on your front lawn?
No.
But you did see those tire tracks.
I did.
No further questions.
All right. And then we get Caitlin Albert. I'm just going to kind of recap hers real quick. Colin was only there minutes. The Colin thing, I don't personally feel like is a really strong. I know, people are saying Colin is the son Brian always wanted. He's kind of a fighter. Maybe he's got some stuff on his knuckles or whatever. I'm still waiting to see that connection to be made. It feels like a weak theory if he wasn't really there that often. I mean, that long, but maybe there's more coming. Everything was fine. No one's fighting. Karen Reed and John O'Keefe never came over. She was the last person to leave around 1:45 or 2 a.m. She walked out and it was actively snowing. She was focusing on not tripping. When they left, she didn't look at the yard where John O'Keefe's body must have been, according to the state's theory, because she was focusing on talking to her boyfriend. Again, first time anybody questioned her was at a hearing where the defense and the Commonwealth were not there. She compares, an acquaintance versus a friend using Brian Higgins and her dad. And then they move on to Kate McLaughlin and Courtney Proctor. They didn't get a ton into it because then they went into an argument outside the presence of the jury, which is going to be the last thing we listen to together. I'm going to hit some questions before we get to it. And the judge is kind of taking it under advisement how much they're going to let them get into impeachment and what they all know about this case. First, I want to get to Bill Smith. Possible explanation. Let's get into it. Chat, talk about whether or not you agree with Bill Smith. Dog let out, escaped, and attacked O'Keefe. He stumbles onto the road, struck by a vehicle leaving at 40 miles per hour, possible reckless/drunk driving. Part 2, Jen sees or is told of the accident, keeps accident a secret to protect the driver, drunk teen. Jen worries and searches freezing question on Google. See Part 3, like a teen she knows or not. You think she'd protect a teen she doesn't know over her friend Karen Reed? Or I guess, does she hate Karen Reed? I don't know. Part 3, several Albert family members made aware that evening, calls to cover bases. O'Keefe's raccoon eyes are the result of severe blow to the back of the head. See Part 4. Bill Smith says again, red lenses cover up, dog DNA and bites. Were any attendees' cars repaired, sold? Higher speed collision explains thrown shoe, significant injuries. So while we listen to this last part, you guys can kind of discuss Bill Smith's theory of what happened in this case. But this is the defense again arguing that they want to get into the connection between Caitlin Albert and McLaughlin.
We have a clear conflict in the testimony. We have a witness who has admitted that her statement has evolved, and she's admitted that her statement evolved after she learned the identity of the house that she was at, which happens to be the house that Caitlin Albert grew up in. When she was confronted with, who is Caitlin Albert, when Jackson asked Katie McLaughlin who Caitlin Albert was, there was a long pause, and then she was and then even the way she phrased it was, I think, telling. I went to school with somebody by that name. There was something to that effect. It sounded ridiculous. It sounded like it was something that she's trying to remember. At that point, we had.
I do agree with him. Her very first answer to that question was like, come on. I went to school with somebody with that name. Almost like, is there two of them? Like Danny Zuko from Greece? I don't know. Maybe there's two of us. It's like, that's what it sounded like. Almost like, oh yeah, I went to school with somebody with that name. Sandy said, loving your animation and sarcasm. And I try not to be sarcastic with such serious topics, but parts of this just have gotten to me. Brooklyn Basement said, do lawyers usually present strongest evidence first? Yes. You want to grip the jury, get them with you, and then they're more likely to believe the evidence you're going to present later. Trish said, spoliation jury instruction for Brian Albert and Brian Higgins. I don't think so, because it was before the judge's order and before spoliation was actually in effect. So under Florida, I think we might have an argument, because if you even know about pending litigation, and hiring a lawyer usually can let people know something's pending. Sometimes we are able to push and get some kind of an instruction there. Joey said 4 calls, 4 answers, 2 phones, but they were neither talked to anyone, all while John O'Keefe is outside dying. Brian and Nicole were very unlucky. Dang phones. It's one way to put it, Joey. That is one way to put it.
4 photos that we mark for ID, HIJ, and K, where we have them together. We have them being Facebook friends. We have a nature of the relationship that she tried to conceal in our career. Since that time, we've been deluged by other photos of the two of them together, including one, intimate photo of them, before them. So when I say before them, I mean Kate went out with 2 college roommates, and the only person who's not a college roommate in that photo is Katie McLaughlin. Katie McLaughlin also said that she never went on anything other than occasional day trips with Caitlin Albert. We now know that that's false. We have them together in hot tub.
Most of this should be allowed to come in for impeachment purposes, even if it's a secondary issue. The credibility of a witness, especially this witness, is really important when she's the one that says Karen Reed said I hit him. So her credibility is really important. This stuff should all come in my. I mean, maybe not all of it if it's cumulative, but they should be able to hammer home that you do know her. You went to Maine. It wasn't just day trip to the beach.
Drinking in a photo that is from Maine, which is about a 4-hour drive away.
When is
That
that?
was, it was posted in 2016. Which is
But when did it occur? Did it
2016
occur?
may seem like a long time ago, and I would agree. And usually it's like, it was 8 years ago. But she said they kind of stopped hanging out after high school, which was 2014. This is 2 years after high school. The Commonwealth has to feel they have a great case to bring it to trial, right? Am I missing something? Are you expecting to see a lot more? Megan, yes. They usually have to feel like they can and will win, or they shouldn't bring the case because justice would not be served if they can't prove this case beyond a reasonable doubt for them to take it to trial. They know it ruins people's lives. I don't know if I was expecting a lot more. I am still expecting more. I'm expecting them to be able to connect these dots. Jason Jones, they knew they were headed over. It was a snowstorm, and not one person in the house wondered why they didn't make it. No text calls to them to make sure they're okay. Great point, Jason. And that's what I'm saying. If we're in a jury room together, we're all looking at this differently. We've all got different friends and different interactions. And if you bring this up, I'd be like, you know what, Jason? That's absolutely correct. But that's why I think a lot of testimonies like, well, we didn't really know who was coming or not. It was kind of a weak invite or offer, but you still wouldn't reach out and ask them. And that's where they're all like, we weren't really friends with the O'Keefes. We would have texted or called our real friends, but not them. But I think that's a great point. Alex, hey, Peter, if you were the defense lawyer for Ms. Reed, would you ask or recommend her to take the stand? In this case, I would. I don't think there's a ton that can, I mean, obviously things can go wrong for her, but nobody witnessed it, right? Nobody seemed to have been with her during the hours in question. So it's kind of just going to be her word. And I think she's going to answer some questions that the jury's going to want to hear answers to.
In 2016? Or
Caitlin Albert. We now know that that's false. We have them.
when is
That
that?
was, it was posted in 2016. Which is
But when did it occur? Did it occur in 2016, or was it posted in 2016?
It was posted in 2016. I think the information, that's when it was a new photo that was uploaded. After 2016. So we know it was after high school, which again contradicts Katie McLaughlin's testimony, because she made it seem like this was just some girl that I knew in high school, and then we happened to be at the same places at various times, but I'm not close with her, despite the fact that I have my arm around her in both of the photos. The other aspect of this, Your Honor, is that she said that she had not, Katie McLaughlin testified she had not seen Caitlin Albert for I think 2 or 3 years prior to January of 2022. We have a baby shower photo that is from June of 2021. They are standing next to each other.
Do you have someone to authenticate that?
June of 2021 now, right before all this happened, way after high school.
Date?
Caitlin Albert will authenticate that date.
Why are you sure of that?
She's going to be showing a baby shower, which occurred in 2021.
Okay.
That's when it's timestamped on social media. And Caitlin Albert, her face and her body are in that photo. Katie McLaughlin's face and body are in that photo.
How many other people are in that photo?
I think there's 6. I have a photo. Get back to the journal. Thanks for ID. Oh, thank you.
Or actually, if I can just see those, I thought these were different photos. If I could have those.
And we should be allowed to explore the bias of these witnesses, particularly the bias of Katie McLaughlin, who purports to give incriminating testimony against my client, brand new testimony that only existed after she learned the identity of the homeowners in this case.
So some good points being made. Future said, really, I don't know that she needs to take the stand, at least not at this point. I don't think she needs to, and it's early on. I'm assuming they have more, right? I don't know, and I also don't know what discovery's been produced from Karen Reed's phone. Are they going to have stuff they can impeach her with? I don't know all that, but when I'm talking about the risks of a defendant taking a stand, Karen Reed doesn't have a lot of them, right? She's a professional. she doesn't have prior crimes, no prior history of anything like domestic violence or anything like that. And basically, her testimony could be as simple as we loved each other. Everything was great. We fought sometimes. That night, I dropped him off there and I didn't want to stay, so I left. That could be her whole testimony, and nobody other than what's already been testified to can really poke holes in that. Again, I don't know what evidence is there, so it's always hard to answer this question. And if the Commonwealth's case ends today, no way does she take the stand. But I'm assuming they're going to prove their case up a little bit more. And if necessary, I would probably recommend that she does take the stand. Diane, Peter, what did you make of Brian and Higgins fake boxing at the waterfall? Nothing really, honestly. I get what the defense's theory is, but I don't make much of that at all, if I'm being honest, unless they can give me more than what they've given so far.
Classic bias and classic impeachment evidence. There's no reason why we shouldn't be able to show photographic evidence of this relationship, much like Mr. Lally shown photographic evidence of the 34th victim, what it looks like. It's intended to assist the jury. And in doing a 403 balancing test, Your Honor, the probative nature of this evidence greatly outweighs any prejudice. She's able to explain these photos any way she wants when Mr. Lally does his direct examination of her. But without being able to get into this, Your Honor, Katie McLaughlin's testimony.
And so, see, this is the thing that I don't know. I didn't know she had a prior DUI. So it's why it's an impossible question for me to answer, because she's not my client. But as far as this case goes, some cases are really scary. Like you have a big lie you've got to answer for. And I don't see a lot of the big scary things for her. Prior DUIs, sometimes that wouldn't come in because it's propensity. But if it's other bad acts, or if they have some kind of Williams rule like we have in Florida and it's coming in because it's so similar to this case, I don't know. So yeah, there are definitely some things to consider as far as her testifying. If it ended today, no way. Somebody said she doesn't have a prior DUI. So I have no idea.
It's like she's wearing a suit of armor. We can't get through it. We have the tools and the evidence to get through it. We have the ability to expose her as somebody that's misrepresented something very important to this court. If we can't ask these questions and we can't get any of these photos, then we're not able to do it.
All right, Mr. Lally, what do you say?
You know, just as far as the authenticity of whatever these is, as far as social media is concerned, there's a
As far as whatever this is,
variety of ways to fabricate that. And I think it's interesting that Mr. Giannetti is really vague about where
so he thinks they might be fabricating things. That's interesting.
these photos came from, or how he knows the specifics that he's so sure about when they occurred, where they occurred, what state people were in, what day it was, who is college roommates of who within these photographs, but has no specifics about where these deluge of photographs came from. More importantly, Your Honor, what I would submit as far as Ms. McLaughlin is concerned is she was entirely consistent, and I did the disparagement as far as what her testimony has been, as far as her statement within the report to Trooper Proctor, her grand jury testimony in this case, and her testimony before this jury on the stand were identical, if not entirely consistent. And again, it's not just Ms. McLaughlin that is attributing this statement to the defendant. The jury has heard from 2 other firefighters, as well as anticipated other witnesses who will testify to these exact same statements that the defendant made outside of the home on that date. What counsel I think is referring to as far as the could I have hit him is something that the defendant said to Ms. McCabe, which was overheard by Ms. Roberts on a speakerphone on the way to Fairview Road. And then she modifies that statement when she's asked specifically about the bruising and how that could have been caused. And it's at that point where she repeats, I hit him, I hit him, I hit him, I hit him. So to then use prior statements to a completely separate witness that have nothing to do with Ms. McLaughlin to try to use that to claim impeachment or bias is ridiculous. And then as far as it applies to this specific witness, when it comes to impeachment
Lally's like, he conveniently doesn't tell us where he got those photos.
and bias, what the case law is very clear about is if it goes to bias of the witness who is on the stand. And the witness in this case is Ms. Albert, not Ms. McLaughlin.
All right, thank you. This will save us some time tomorrow.
So the judge is taking it under advisement. And we'll see how it ends up going. Lady Law said, when is the state presenting their case? Oh. Haha. See what you did there. Furious. Are these witnesses subject to recall? I haven't heard them ask them every time. I've kind of skipped through when they've gotten on and off the stand, but if they go watch the case, they're not going to be able to come back and testify. Little April, in my opinion, and Albert told Katie to say that. Maybe. And I'm not sure. But that's all we got tonight. So if everybody will hit that like button before you bounce out of here, we will get to 10,000 likes, which would be wild. We've never had 10,000 likes on a Karen Read video. So that will be a first for this series and this trial. And we're just getting started, right? We're like a third of the way through. So if you guys are going to be here, you're going to join us every time we're doing a breakdown, a recap, reaction to this case. Let me know in the comments. If you're new here from this case, let me know in the comments. It's been awesome. I appreciate you guys being here. I appreciate you sharing all your questions and comments with me. It adds so much to the conversation. But that's all I've got for this one. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.